Hello students, myself Dr. Harpreet Kaur from Army Institute of Law Mohali. I will be discussing with you the topic of freedom of press, fourth pillar of democracy. Introducing the topic, democracy is described as the government of the people, by the people and for the people, or it is considered to be the rule of the people through their elected representatives. Democracy is balanced by the three pillars of democracy, namely the executive, the legislature and the judiciary. But now in this era, democracy also leans towards the fourth pillar, and that is the media or the press. The term media, fourth pillar of democracy, was coined by Thomas Carl. The merit of democratic system is that it gives freedom of expression and a space is given to each individual. Press is used to create awareness about various social, political and economic activities. Media is like a mirror to the world, which reflects the true and harsh reality of the world, as media is trusted by everyone and people always trust actual and honest news. The main purpose of the press is to provide accurate news in front of people, but the truth is not always shown by the press, because of which people suffer and at last it impacts our democracy. In the world's largest democracy, the freedom of speech and expression is the most crucial fundamental right made available to the citizens by the Constitution. The press is considered as the fourth pillar of democracy and it plays a vital role in countries' social, political, economic and international affairs. Thus, it goes without saying that free press is a sine qua non for a democracy to survive and thrive and preserve the ethos of the good and transparent governance. India is the world's largest democratic country and the fourth pillar of this democracy is the press. A strong nation should be developed with the unrestricted participation of the press, as it is a necessary tool for mass communication. If freedom is the breath of a healthy press is the foundation of a healthy democracy. By allowing the press to voice their thought in support of or opposition to the government policies, a nation promotes independent thought and democracy. In the past, India has witnessed the rise of political parties, falling of the governments, crashing of the economy and stock markets getting skyrocketed, all based on the information broadcasted regarding by them by the media. Restriction on the right to free speech would undoubtedly be anti-democratic and hinder the press capacity to disseminate the truth. To expose instances of corruption and violation of human rights, a free press is vital. The globe celebrates World Press Freedom Day on May 3rd to promote press freedom and call on all governments to uphold the rights of press institutions and media organizations across the world. The day serves as a reminder for media organizations to consider the limitations imposed and the growth of websites that promote press freedom. Freedom of press, its meaning. Freedom of press refers to the minimal interference of the state in the operation of press on any form of communication, including print, newspapers, magazines, journal or reports, including audio, it can be radios or podcast, video, that is news channel, OTT platform like YouTube, and over other electronic medium like news apps, social media feeds, etc. The liberty of the press, in the words of Lord Mansfield, is consist of printing without any license, subject to the consequence of the law. Therefore, we can conclude that freedom of the press refers to having the freedom to express what one pleases without any prior permission from the law. Press is a medium of availing knowledge and spreading the vital information of events, developments, incidents of national interest to the whole nation, and thus free and fair operation of the press makes the backbone of civil society, which is capable of critical and independent thinking and forms its opinion about the country and the government after scrutinizing the fact of the situation wisely. As per Indian Express newspapers versus Union of India, this is 1985 judgment, Supreme Court cases, page number 64. The objective of the press is to supplement the public interest by printing the facts and opinions without which the citizen of the country cannot make well informed rational judgments. Freedom of the press is in the crux of social and political intercourse. It is the paramount duty of the judiciary to prop the freedom of press and refute all laws and executive action that interfere with it as opposed to the constitutional provisions. Now, I will be discussing freedom of press in the countries around the world. The importance of freedom of press as the fourth pillar of democracy can be seen almost all the democracies around the world. Some instances are as follows. First is United States. The First Amendment of the US Constitution protects freedom of press, stating that Congress shall make no law abridging the freedom of speech or of the press. While there are occasional tensions between the government and the media, journalists in the US generally enjoy significant freedom to report on a wide range of issues without fear of government censorship or persecution. Next country is Sweden. Sweden consistently ranks high in press freedom indexes. The country has strong legal protection for journalists and its media environment is characterized by a high degree of independence and transparency. The Swedish Constitution explicitly protects freedom of expression and of the press. United Kingdom. Press freedom in the UK is supported by legal protections including the Human Rights Act of 1998, which incorporates the European Convention on Human Rights into UK law. However, there have been debates and controversies surrounding issues such as government surveillance of the journalists and media ownership concentration. The next country which we will be discussing is United Nations. Freedom of the press is the principle that communication and expression through media is a fundamental right. Article 19 of the Universal Declaration of Human Rights states that everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive and impart information and ideas through any media and regardless of frontiers. Now, I will be discussing freedom of press in India. The Indian Constitution provides legal protection for press freedom along with upholding moral ideals, national sovereignty and national integrity. This combination of protections allows for independent journalism in India. The majority of Indian Legislative Institute claimed to be ardently devoted to the right to free speech in its broadest sense based on Article 19. The only clause of our Indian Constitution that specifically mentions citizens' freedom of speech and expression. The laws dealing with the freedom of press are as follow. Number 1. The Press Council, a statutory organization that was first founded in India to support democracy and free expression, fought to enact the Press Council Act in 1978. Number 2. Article 19 clause 1 subclause A states that in order to maintain democratic principles and practices, individual must have the freedom to express their thoughts and views in public. Number 3. Article 19 clause 2 of the Constitution aims to moderate freedom by setting essential restraints in order to safeguard law and order, state security, morality and decency. Article 19 clause 2 does impose some limitation to protect the country and its integrity. The installation of limitations may be necessary in response to threat to India's sovereignty and integrity, state security, law and order, good relations with other countries, etc. Coming to the scope of freedom of press under Article 19 Clause 1 Subclause A. Freedom of press is implicit under Article 19(1)(a) of the Indian Constitution, which provides for the freedom of speech and expression under Part 3, that is the fundamental right. It does not explicitly provide the term freedom of press anywhere, but it becomes quite clear from this Constituent Assembly debate when Dr. Bhimrao Ambedkar replies to a question of Article 19 not including the freedom of press, saying that the press is just another method of quoting an individual citizen, and when anyone chooses to write in a newspaper, they are merely exercising their right of expression, and thus there is absolutely no need to separately mention the freedom of press. The various freedoms given to the press are as follow. Freedom to spread information. Without this liberty, freedom of press is nugatory, though this right is also implicit in the freedom of expression. In case of Ramesh Thapar versus State of Madras 1950 Supreme Court judgment, page number 124 makes it explicit. The main line of the difference between the freedom of press and freedom of expression for an individual is that an individual can't communicate to masses on his own, but a press can by means of its publication on various mediums like print, broadcast, electronic, etc. Thus, freedom to spread information is an intrinsic part of freedom of press. Next is freedom to criticize. The press, just like individuals, has the liberty to criticize the government, its officials, its policies, its action, its laws, its statement, etc. However, the press cannot abuse this right and cannot provoke the public against the government, or cannot abet riots, rebels or mutiny or insecurity of the state or the government. Freedom to receive the information. If the press is not equipped with the information, it cannot empower the public with the knowledge, and thus the right of expression will become futile because there will be no access to information on whose basis anything can be expressed. Next is freedom to conduct interview. This right is necessary to bring in first-hand knowledge from the experts on the particular subjects and to enlighten the society at large. Though this right is not absolute, there are three caveats to it which are as follow. First is, interview only take place on the consent of the interviewee. Second is, interview shall stop when the interviewee wants it to be. And third, interviewer can't force interviewee to answer any question against his or her will. Now coming to freedom to report court's proceeding. In the words of Jeremy Bentham, the soul of the justice is publicity. In case of Sahara India Real Estate Corporation Limited versus SEBI, AIR 2012 Supreme Court, page number 3829, Supreme Court held that it is the right of the media to report the judicial proceedings. In case of Saroj Iyer versus Maharashtra Medical Council of Indian Medicine, this is 2002 judgment of Bombay High Court given on page number 97. The Supreme Court held that right to print faithful reports of the legal proceedings witnessed is available even if it is against the quasi-judicial tribunals. Next, I will be discussing freedom to attend and report legislative proceedings. Article 361 of the Constitution equips us with the right of publishing a report of the parliamentary proceedings. The only limitation of this freedom is that there should be no mala fide intention behind such publications. When the right of reporting of the legislative proceeding, which is implicitly envisaged in the right of expression given under Article 19, is in discord with parliamentary privilege, that is Article 105 and Article 194, the right of speech and expression shall overshadow the parliamentary privileges. The freedom to act as an advertising platform. The major income of most of the presses come from the advertisement, whether it is from a radio or a news channel or mobile application or a newspaper. We have a case, it was after Tata Press Mahanagar Telephone Nigam. This case is of 1995, Supreme Court cases, page number 139. the Supreme Court incorporated the right to advertisement as a part of right to freedom of expression. Next, coming to freedom to broadcast. In the modern age of technology, power to broadcast is essential as it is one of the major channels to spread information. This right not only includes broadcasting on news channels, radios, but also on internet like websites, blogs, mobile applications. We have witnessed some of the most reliable journalism on these platforms like Alt News, The Print, The Wire, Quint, etc. Now, I will be discussing with you the reasonable limitations on the freedom of press. Unrestricted freedom, that is liberty, without any reasonable restriction on it, always hampers the very purpose of granting that freedom in the first place, that is to empower the individual, as it backfires and make the rights of individual collapse with one another. As freedom of press derives its powers from Article 19(1) subclause A, it is also subjected to the reasonable limitations imposed on Article 19 clause 1 subclause A under Article 19 clause 2, which are explained as follow. Now, what are the limitations? First is sovereignty and integrity of the state. It was inserted by an amendment to control the extreme reactions of the people who were protesting for separate entities of the different regions of India. Any form of speech or any expression which hampers the sovereignty or integrity of the state would be covered under this restriction. The right of freedom to speech and expression can't be allowed to be used as a weapon against the sovereignty or integrity of the state. The next limitation is security of the state. The freedom of expression cannot be exercised in a way so that it becomes a threat to the security of the state in any manner. Any communication which incites the people to cause social unrest, rebels, violence, riots, etc. against the state and its subject would be covered under this restriction. In a leading case of State of Bihar versus Shalabala Devi AIR 1952 Supreme Court, page number 3 to 9, the Supreme Court held that speeches made by any person, it can be citizen or a non-citizen, which encourage the people to commit offence like dacoity, murder, robbery, etc., is without a doubt a threat to the security of the state. Hence, such a speech will be considered as a prejudice towards the sovereignty or integrity of the state, and the order to stop or curtail such communication is covered under reasonable restrictions of Article 19 clause 2. The next limitation is public order. This term was inserted by the Constitutional First Amendment Act of 1951. This clause was added to curtail the effects of Ramesh Thapar versus State of Madras 1950 Supreme Court 1-4, where the Supreme Court had held that the right to circulation is an intrinsic organ of the right to freedom of expression. The term public order has a broad meaning and covers a multitude of action which may endanger the security of the state. In Madhulimai versus Subdivisional Magistrate AIR 1971 Supreme Court, page number 2486, it was held that the term public order can be construed as no insurrection or riot or disturbance to public peace. Next leading case is Ramji Lal Modi versus State of Uttar Pradesh. This is of 1957 Supreme Court judgment, page number 622. The constitutionality of the section 295A of Indian Penal Code was being questioned. The argument advanced was that the mentioned section infringes the right to freedom of speech and expression guaranteed under Part 3 in Article 19(1)A under the Constitution. The petitioner, who was the printer, publisher and the editor, was held guilty of the offence under section 295A of IPC. Further, it was contended that this section has no protection under the reasonable restrictions of Article 19 clause 2 of the Constitution. The Supreme Court dismissed this argument and held that if an individual, by exercising his or her right to freedom of expression, causes public disorder, then he or she can be prosecuted under the mentioned section, which comes within the purview of reasonable restriction. The next limitation is decency or morality. For preserving the decency or morality in the country, the state has the authority to limit the freedom of speech and expression of an individual. Further elaboration of this ground is reflected in section 292 to 294 of IPC. The mentioned section lists down some acts as crime such as selling obscene publications to young individuals, making indecent gestures in public places, etc. In a leading case of Ranjit Udeshi versus State of Maharashtra, 1965 Supreme Court 881, the Supreme Court held that Section 292 of IPC is constitutional as it prohibits obscenity in public places and promulgates public decency and morality. It was further supplemented in a leading case of Chandrakant versus State of Maharashtra, 1970 Supreme Court 1390 by Supreme Court that while tackling the question of decency and morality, the court has to consider the proposition as to whether or not the indecent or immoral acts were sufficient to pollute the minds of the young individual, or is there a possibility that their minds would become depraved. The next restriction on the right is contempt of court. There is no doubt that a freedom of speech and expression is very crucial for societal development, but on the other hand, providing and maintaining justice and equity is also equally substantial. Though the freedom of speech and expression reckons, but it can't be wielded to cancel out core section of justice. The Supreme Court under Article 129 and the High Courts under Article 215 of the Constitution is empowered to take punitive actions for contempt of court. It was further held in C.K. Deftree versus O.P. Gupta 1971 judgment Supreme Court page number 1132 that section 228 of IPC and article 129 of the Constitution are valid and are covered within the purview of reasonable restrictions enshrined in article 19 clause 2 of the Constitution. Thus, we can infer from the above discussion that freedom of speech and expression is prone to article 19 clause 2, article 129 and article 215 of the Constitution. Next is defamation. Article 19(1)(a) is no manner gives a license to cause damage to the reputation of a person in the name of freedom of speech and expression. Causing damage to an individual's reputation is considered as defamation, and it is a stringent limitation to the right of freedom of speech and expression. No one is allowed to expose a person to hate, ridicule or contempt by means of any expression, signs or gestures. Defamation is considered as a very stringent act and therefore it is prohibited by the civil law of torts. Also, it is an offence under section 499 of IPC. As something is enshrined as wrong under two statutes, it is obvious that it has a defence under reasonable restrictions of article 19 clause 2 of the Constitution. The next limitation is friendly relations with foreign states. Just like the term public order, this ground was also inserted in article 19 clause 2 of the Constitution via Constitution First Amendment Act of 1951. This main objective of incorporating this restriction was to counter the antagonistic and a malified propaganda against any foreign country which may have friendly connections with the Republic of India. Such activities can jeopardize the government's effort to promulgate and maintain friendly relations with the foreign nations and bring lucrative results out of those results for India. In Jagannath versus Union of India, AIR 1997 Supreme Court 811, the Supreme Court held that all Commonwealth countries are foreign countries for the purpose of Article 19 clause 2. However, another fact to take cognizance of this is that members of the Commonwealth countries including Pakistan aren't the member of foreign state for the purpose of the Indian Constitution. Next is incitement to an offence. As per criminal jurisprudence, the act of incitement or abetment to an offence is a distinct and independent offence per se, exercising the freedom of speech and expression to incite an offence would be considered as a threat to the public order. Just like the term public order and friendly relations with the foreign states, this ground of reasonable restriction was incorporated in the Constitution via Constitution First Amendment Act of 1951. In case of State of Bihar versus Shaila Bala Devi, EIR 1952, Supreme Court 3-9. It was held by the Supreme Court that any communication which leads to incitement of any criminal act can be restricted, and any order for such ban will fall within the purview of reasonable restrictions envisaged in Article 19, Clause 2 of the Constitution. The above mentioned 7 grounds of Reasonable Restriction Act as a line in the sand for the demarcation of the right of freedom of speech and expression, which also includes the right to freedom of press. So, one can infer that the right to free press prevails within the boundaries of reasonable restrictions enshrined in Article 19, Clause 2 of the Constitution. Now, concluding my topic, I can say, in Nelson Mandela's word, press is the foot soldier of democracy, the lifeblood of democracy. To communicate its opinion with the public and defend the democratic way of life, the press needs the freedom to express itself. Although press freedom is crucial, authorities are starting to impose certain limit on it as concerned about incorrect information, data manipulation, fake news, populism, etc. develop in the current environment. Press freedom should not be interpreted as a right to publish and speak negatively about anyone. Instead, it should provide open access to information and constructive criticism of the conduct of politicians. The press must publicly disclose corruption related scandals without any pressure. In order to protect journalists, the government must also act in good faith by passing the Protection of Journalists Act. Currently, India's rank in the World Press Freedom Index by Reporters Without Border is 140th amongst 180 countries. This rank has taken some serious decline in the last decades, from 133 to 136 in 2017, 136 to 138 in 2018 and 138 to 140 in 2019. This dip is due to the beating, prosecution and even death of the journalists on the line of the work. We often see videos of journalists getting lynched and being publicly beaten for trying to expose politicians or government officials. This shows some serious concern pertaining to freedom given to the press in the country with the world's biggest constitution and bureaucratic setup. Press is supposed to be the voice of the public to the government, but in modern times a contrast to this can be observed, where some of the major mainstream media houses are marketing the political parties while criticizing the opposition parties and not discussing the relevant issues like public welfare, corruption, analysis of government scheme, etc. Though it is also true that forums like WhatsApp, YouTube and Facebook, which are totally independent, have become prone to fake news leading to mob lynching, fear mongering, hate speech, propaganda spreading and indecency promoting, which highlights the need of some reasonable restrictions of the press. Freedom of press is the cornerstone of democracy, a fundamental right that empowers society to remain informed, hold power to account and foster open discourse. Protecting this freedom is not merely a legal obligation, but a moral imperative essential for the preservation of liberty and the advancement of society. I hope you liked the lecture. Thank you and have a nice day.